Okay, so this talk is about whether it might be possible to hold High Court judges to account if they make decisions that contradict the clear intention of the Australian Constitution. So there is, under the Criminal Code Act, Commonwealth Criminal Code Act, a crime called treachery, and it applies if a person engages in conduct with the intention of overthrowing the Constitution. So that's 80.1ci, the clause, and its penalty is imprisonment for life. So could we possibly use this law to hold federal court judges to account if they make decisions that contravene the Constitution? Now, the reason why this might work is that if you're indicted for any offence against any law of the Commonwealth, the trial will be by jury. So these judges would then be being judged by a citizen jury. So that might provide a form of overview, of oversight, if you like, for federal court judges, since there is no other further area of appeal above the High Court in Australia. So what I'm suggesting here is that in cases of clear decisions that have gone against the intent and meaning of the Constitution, we could potentially charge federal court judges with treachery under this section, and then we could have a trial by jury. So this would need then someone to prosecute the judges, and I believe in Australia it is possible to have private prosecutions, but they can be stopped by state prosecutors. But if there was it would require basically a state government to be on board for this to work. Otherwise, it would get stopped very quickly. But if you had a government in place that was supportive of this, then it's quite possible you could bring one or some of the federal court judges to trial by jury if they make a decision that's against the Constitution. So why am I bringing this up? Because we're getting a lot of constitutional challenges based on lockdowns. Now, a couple of these have been brought by Clive Palmer, who's a very wealthy man, wealthy enough to pursue these cases. And he had a case recently whereby he challenged the ability of states to close the borders as they have been doing. So they're saying no one from another state can come in. This is mainly with the intention of stopping infected people entering the state from other states. So he lost that challenge, and this is an article by Anne Toomey, who's a well-known professor of Australian constitutional law. Now, one of the things that comes into play here is this section 92 of the Constitution. This is what the challenge was based on. It says the movement of people between or among states shall be absolutely free. But Anne says here, or Professor Toomey says here, that the High Court has previously accepted it can be limited if it is reasonably necessary to achieve another legitimate end, such as the protection of public health. So for me, a question comes up straight away. How can you take a term such as absolutely free, not just free, absolutely free, and then limited based on some law made by some other government? So to me, that's already starting to enter questionable ground. So there is that problem of restricting absolutely based on health. But even if let's accept that is legitimate, and there are circumstances in which that could happen. It seems to me that if we pop up here, that the only government that could do that would be the federal parliament, because this is a federal constitution and it says legislative powers of the parliament. And clearly, quarantine is a power of the federal parliament, not state parliaments. So if any parliament should be able to restrict movement based on, for the purposes of quarantine, then to me, that clearly sits within the powers of the federal government. And now, maybe the federal government isn't exercising that power, and the state governments are. So that brings up an interesting question. But at the very least, it is possible, because state laws have to give way to federal laws where they contradict each other. It is certainly possible that the federal parliament could pass laws allowing people to move between states during quarantine periods, or have some rules around that, which would effectively invalidate the state rules. So what I'm saying is, maybe in this situation, the best solution is for the federal parliament to pick up its powers and exercise them, overriding state legislation in this matter. Because the states are just doing state of emergency, which I would assume would normally be things like fires and floods and things, not quarantine. Quarantine sits under the federal government, and I believe it's a failure of the federal government to not have picked up those powers and used them. So that would actually resolve this problem. I think that if you're going to interpret absolutely free as being in any way limited, it can only be limited by the same constitution that gives those power, gives that freedom, and that is this power to quarantine. Yep. So that's that thing. So, all right. So anyway, we can potentially, if federal judges are acting against the Constitution, there may be potentially the possibility to take them to a trial by jury. Why does that matter in this case? Because Clive Palmer has taken another case to the federal court, and this one is the fact that the Western Australian government was going to stop people entering unless they were vaccinated. Now, they're doing that under their state emergency powers to quarantine. But he's challenging them on that, saying, well, the evidence is that vaccinated people carry the virus just as much as unvaccinated. Yeah. So, so this is a different, he's arguing this is a different case to the previous one. So the previous one failed, and I've talked about whether that's legitimate or not. I don't think it is. I don't think that's a fair decision to restrict those powers based on state legislation. I think it could only be maybe possible under, it could only be possible under federal legislation. Anyway, he says that the fact that they're making people take a vaccination no longer fulfills the state's act requirements for the purposes of emergency management, because it's not helping the emergency management to let vaccinated people in and not unvaccinated people, because effectively they both spread the virus. So that's what we're seeing. So it'll be interesting to see how the High Court interprets that in relation to the Constitution. But again, I think this whole thing could be avoided if, well, this problem might still come up, but you would avoid a lot of these problems just if the federal government would pick up the quarantine laws and act on those. So anyway, so he's going to challenge this restriction. This Zimmerman is head of law at the Sheridan Institute and a former law reform commissioner. So one assumes he has a fairly decent understanding of what he's talking about. He said that last year's ruling, the one I just talked about states being able to restrict travel from out of the state, spurred disagreements in the legal community, as many believed it went against the nation's founding principles. He says the Constitution is very clear. It should be absolutely free. All right. Okay. I'm not sure. I think it could be potentially restricted by the federal government. Now, so anyway, he's quite critical he says, the judges and justices of the High Court have made very controversial decisions that makes me suspicious as whether they're going to faithfully uphold the rule of the law. So that is where I say, what can we do if they don't? What can we do if we find they're not upholding the rule of the law? And this is what I'm suggesting. We could take them to a trial by jury under the um, Commonwealth Crimes Act. He thinks these judges are not going to challenge the status quo. I think they're under too much pressure to do what the politicians want. So if that's happening, then they are failing in their duty, which is to go by the law, not by what they want the law to be, not by what politicians want the law to be, but by what the law says. They are not going to do the right thing, in my opinion, unfortunately, he says. So what do we do if they don't? If they start making decisions that contravene the Constitution of Australia, what do we do? The other reason why this might become a problem is because of mandatory vaccinations. I strongly suspect that there will be a High Court challenge at some point about mandatory vaccinations, at some point fairly soon, I would say. Now, the Australian Constitution says that the federal government can make laws in provision to medical benefits and allowances, so they can allow you to get vaccines, etc. But it's not authorised to use civil conscription. Now, according to this, Chief Justice John Latham of the High Court has, in previous decisions, I imagine, defined civil conscription as the compulsion of law to require individuals to engage in a particular occupation or work. So the federal government is not allowed to require you to take the vaccine, it would seem. All right. So I suspect this will be a challenge at some point. Whether state governments can do this is another question. I don't know enough about the relationship of these two to say anything about that. But certainly the federal government looks like it can't do that. Now, it's quite possible that high courts will rule that under certain circumstances they can. Just like under certain circumstances you might say intercourse between the states is not free, even though it says absolutely free. In this case, they might say, well, not authorised to use civil conscription except, in an emergency. But this starts to get even more dodgy because, there's nothing in the federal constitution that I know of that would allow this to be weakened. In the case of people moving from state to state, you could possibly argue it might come under quarantine because quarantine is specifically listed as a federal power. But there's nothing that contravenes this or countermands this anywhere else in the Constitution that says, well, the federal government can force people to be vaccinated in medical emergencies. There does not seem to be anything in there that would allow this. So if the federal court gets this challenge and does decide that vaccinations can be done under certain circumstances by state or federal government, then I think that's the point where we might want to start saying they're now acting in contradiction to the Australian Constitution. Particularly, they say the federal government has that power. So, and it looks like, as I say, quarantine should be a federal responsibility, and therefore controls for quarantine should be a federal responsibility, and they should not be in the state system. And if they are in the state system, the federal government has the ability to override those laws. So this is going to be an interesting battle. I think could be a major battle in Australia, and it's something that might threaten to undo our Australian Constitution and people's commitment to it. So I think it's going to be a very important case if it comes up. It's going to be something people are really prepared to take a stand on, and it's going to be a knotty problem if there are suggestions that the legality of mandatory vaccinations is in any way under question if they're enforced. I think that's going to be a really interesting battle. Of course, there is also arguments that these things can be done Under common law, you could fight this. Under common law, all competent adults can consent to and refuse medical treatment. And if they don't consent, there may be legal consequences for health professionals giving them. Under the law of trespass, patients have a right to not be subjected to an invasive procedure without consent or other lawful justification, such as an emergency or necessity. I don't know when this was last updated. 20th of 5th, 2014. Okay, so that's the thing. Is there a lawful justification for forcing people to get a vaccine that has not yet completed the regular um, uh, trials and studies to know if it's safe? So this is not just a normal vaccine, by the way, keep in mind. It's an experimental treatment that still has not been thoroughly fully approved. So that's another interesting thing. Even if you can force someone to take a treatment, can you force them to take an untested treatment? And how does that impact on the study? If you're forcing the whole population to take a treatment, you then have no control group, right? I mean, it's not possible to have a control group. So you can never then sort of prove that the treatment caused the problems that it causes. It's a very dangerous thing to do, to insist that everyone gets a treatment, because then if everyone starts getting cancers or something, they could say, oh well, it's because of global warming or something, right? Not the vaccine, and you can never prove it otherwise. So this is a very important battle, um, and one I think people, might be the cross some people choose to die on, literally. All right, um, so we'll see what happens with this situation, and um, hopefully the courts will do the right things and will respect people's freedoms. But if they don't, then there might be legal ways around that. Possibly we can take them to a jury and then let a jury decide. Now the jury might agree with the court, so that might not solve the problem for people who think that they've the courts have misinterpreted the Constitution. It's not guaranteed to fix it, but it's one possible path. Thank you. Right. Well, there's one other thing I'd like to talk about in relation to High Court decisions. And what I want to talk about is Mabo versus Queensland. So this is where there was a case brought to the High Court about whether Australia was terra nullius when Europeans arrived. So it was in the history books and everything. It was sort of stated that Australia was considered to be unoccupied when Europeans arrived because there was no permanent buildings, etc. And therefore British law could be applied. It could be basically claimed by England or Britain, and the British law could be applied across the nation. And so this was challenged in this Mabo case, I think in the late 80s, and it was to do with basically to do with who owned the land in a sense. But so it went to the High Court, and the High Court then had to decide, well, was the land empty when the Europeans arrived? If it was, then there's no native title, effectively, or was it occupied? And if it was, then what's who owns the land, and what's the legitimacy of European law in the country? So interestingly, they sort of hedged their bets. They rejected terra nullius. They said no, it was not empty, it was occupied, but colonial law applies anyway. Yep. So, well, not colonial law, sorry. British law. British law applies anyway. Yep. So, so that's a strange position because it doesn't establish any basis for the British law to apply. I mean, if they had said that, okay, the land was occupied and it was conquered, then you could say, well, okay, it's applied under the fact that the British conquered it. But they didn't say the British conquered it. They just said that it applied without establishing a basis for it applying. So they've hedged their bets because if they'd said it was not conquered, then maybe British law doesn't apply. Maybe this court has no legitimacy because it's part of the British system. Yep. And we should go back to native law because we're just here by accident. And if it was conquered, well, fine, British law applies, but also under the colonial rules at the time, when the Federation of Australia was established, native law should also apply. So let's just have a look at that. If we go to here, this is an article. So I'll just show you which article that is. It's the policy of recognition of Indigenous laws in this case, British colonial Africa, okay, by Gordon Woodman. And if we come to PowerPoint here, we can see that the initial constitutional order in the British African colonies in the period of the 1870s to the 1900s, so that's a period in which the Australian Constitution was created, included the establishment of judicial systems. The British lawyers in government service in London were among the decision makers. The legislation they drafted generally required the superior courts in each colony to apply English law, but also to apply or be guided by Indigenous laws. Furthermore, their schemes preserved or established native courts, which were to apply Indigenous law in most cases. So it looks like that if you're to be consistent in how they deal with their colonies, that if England had, if Britain had conquered Australia, they would have been required to allow Indigenous courts and Indigenous laws, right? But so clearly the High Court didn't like that idea, and so they decided to sort of come up with this nonsense decision, which says, well, we didn't conquer them, so therefore they can't have the same rights as the African colonies had to have their own laws. But it wasn't terra nullius, so we can still apply our laws. And they're in this sort of no man's land, this sort of um, Alice in Wonderland type lawmaking realm of it not being one thing or the other, but British law applying anyway. So they've really hedged their bets. I think it was an ignoble decision that did them no credit, and and probably denied some rights for the Indigenous people in Australia and recognition of them. That, as you can see later on, there was the movement to introduce native title laws to sort of address this. But I reckon the High Court really dropped the ball there. They didn't want to rule themselves illegitimate by saying they had no right to be there, and they didn't want to say, that actually we conquered them, because that would, give back something to the, well, realize that that would require them to recognize and address a long outstanding injustice. So I think that was a terrible decision, and that's why I don't trust the High Courts. I don't trust them. They will make decisions, it seems, that are politically and practically expedient over ones that are based on solid legal principle. It's a very strong indictment of the High Court system that they come up with this.